Hi guys, today I want to look at a short memorandum or at least short feedback on your test, your JUR110 test. So I want to start off by congratulating you. I think most of you worked really hard and I can see it in your work. Most of you attended class and most of you made the most out of your tutor classes and your tutorials. So thank you very much and congratulations. So let's look at our first question. Our first question, of course, 1.1, dealt with the classification of the law. And very important, as we practice this in class and we've said numerous times, in your test I also only ask you for the area and the immediate subdivision of the law. Now, if you go to your mind map or even to the diagram in your textbook, some of you went all the way back to national or international law, which was, of course, completely unnecessary because you only had to deal with the first area and then the subdivision of the law. Okay, let's go to our scenario and see what are some of the possible classifications that you could have used. The first one, of course, has to do with the murder of her estranged husband, the one that she is now in the Supreme, or that she's now appealing the verdict of guilty. So this is, of course, murder is, of course, classified as criminal law. And what is criminal law? Criminal law, of course, deals with the principles applicable to all types of crime or where people are presumed to have committed crimes. And this, of course, belongs to the subcategory of public law. And why do we say public law? Because the state is, of course, involved in prosecuting her for the alleged crime. All right, the next possible classification that you could have made had to do with the bail hearing and the sentencing, which of course has something to do with criminal law, but more specifically with criminal procedure. And criminal procedure, of course, deals with the procedure, the steps by which criminals are brought before the court and tried for their alleged offences. And this, of course, belongs to the subdivision of, there we have it, of adjective or procedural law, which of course deals with how one goes about enforcing or protecting rights and duties. Now, another possibility had to do with the evidence, of course, and many of you identified the law of evidence. So the law of evidence as one of the possible classifications applicable to your scenario. And if we go to our diagram again, evidence, of course, once again, law of evidence has to do with the kind of evidence that's produced to court or that's brought to court, the admissibility or not, or inadmissibility of such evidence, which of course belongs to, once again, the adjective law or the procedural law, which focuses on how one goes about enforcing or protecting rights or duties. All right, another possible classification that you could have made had to do with the residence and the fact that the house is now on the market for 2 million rand, which of course has to do with the law of property. And what is the law of property? The law of property, of course, regulates the rights of people over certain types of objects or their things, which of course belongs to the subdivision of patrimonial law. And patrimonial law has to do with people and their assets. All right, another possible classification has to do with her insolvency. And many of you here describe insolvency law and describe the hybrid of insolvency law, which is completely unnecessary. And if you remember in class, I also said, don't go too deep. Insolvency in this case merely has to do with the law of persons. Persons, why? Because in our scenario, the law of persons, it has something to do with her status now as an insolvent. And the subdivision is, of course, private law. Why private law? Because it is the law that deals with or regulates the law between two private persons. In other words, acting without the state's involvement. Now, the last classification is, of course, the classification that has to do with a civil suit and her vehicle accident. And here, once again, it's quite easy because we are looking at the delict. The delict, of course, where there was a delict and the person suffering harm can ask for compensation, and of course belonging to the subdivision of the law of obligation, which very easily regulates personal rights and obligations. So half mark, 5 different classifications. If you had more, that's very nice and I appreciate it, but I only marked 5 classifications, and in 2 marks per classification, 1 for the specific division and half mark then for the explanation of your divisions. All right. The next question deals with the principle of stare decisis and the impact of this judgment on future comparable cases in the High Court. And this is once again quite easy. What is the principle of stare decisis? It means that the courts must stand by their previous decisions. Now, what do we mean by previous decisions? Not all previous decisions. What kind of previous decisions? Well, we know that courts are obliged to take into consideration their own decisions, but then also decisions of the higher courts. So in other words, the lower courts are bound to the decisions in the higher courts. And when does this rule of stare decisis apply? When cases are similar in terms of facts, of issues, and questions of law. So, in other words, in our scenario, what is the impact of this specific decision? Well, in our case, it means that the High Court is now bound to the decision in the Supreme Court of Appeal, as the Supreme Court of Appeal is, of course, the highest court in all appeal matters. Remember, Constitutional Court, the highest court in all constitutional matters, but this was not a constitutional matter, it was merely an appeal matter. So, if you look at mark division, you got a mark for stand by previous decisions. You've got a mark for the courts need to stand by their own decisions. The lower courts are bound to the decisions in the higher courts in cases similar facts, issues, and legal questions. And in this case, the High Court is now also bound to the decision in the Supreme Court of Appeal. All right. Now the next question deals specifically then with various sources of law that could possibly find application, and then I ask you to explain what kind of authority these sources of law has. Now, of all the questions, this was maybe your least fantastic question. You did not do so well in answering this specific question. So, okay, the first thing, of course, is the Traditional Courts Bill. And many of you explained that this was customary law or indigenous law. But the Traditional Courts Bill is really legislation. And what is legislation? Of course, what's the definition thereof? It is written rules properly promulgated. Very easy. The next source that we could possibly refer to or identify is, of course, the customary law. And what is the customary law? I wanted you to say something of a specific community and a custom that they've lived for a long time and that they regard as law or that they regard as binding. The other possible source of law is, of course, case law. And what is case law? What is the definition of case law? Well, case law has to do with the interpretation of the law, how we interpret or how the courts interpret the law. So, legislation, customary law, and case law, all three of them belong to what we call primary sources of law, and we know that primary sources of law are, of course, binding sources of law. Alright, then the last kind of source identifiable in our scenario is, of course, the secondary source of law. Now remember, secondary sources of law, they are not binding, they are merely persuasive. And in our scenario, it is, of course, this article in the Die Rebus. The Die Rebus, of course, is the journal. The Die Rebus is a journal wherein we find commentary of modern-day legal scholars in this legal journal. So, the sources of law, legislation and an explanation or definition thereof, customary law and its definition, case law and its definition, and then primary sources as binding law and secondary sources, again, as binding law. Now, in the next question, I am not even going to look or discuss the next question because you did exceptionally well in answering this question about the single system of law. And if you still feel unsure about the single system of law, please go back to your slides and to your mind map. Most of you correctly said that in terms of this act, it is not, according to section 39(2), promoting the spirit, object and purpose of the Bill of Rights. It is invalid because it's discriminatory. It does not purport equality. In fact, it's discriminatory in terms of women, but also it does not purport access to justice because they cannot use any court. So well done and congratulations. If you still feel unsure about this question or the answer to this question, you are welcome to ask me or to speak to your tutors about it again. Then question 3, again, very easy, and we also focused on this a lot in class. The 17th and 18th century Roman Dutch law as influenced by the English law, and here really we focused, or I wanted you to focus on the things that we focused on in class. Remember, we worked through this question. We started off in 1652 with the Jan van Riebeeck and the Dutch. And they, of course, brought the Roman Dutch law to the Cape. And then the next big moment, we said, was, of course, the arrival of the English. And this was, of course, in 1795, but it was the first English occupation. And although they did not change so many things, they started focusing on changing the language, but then also they tried to streamline some of the procedural law already, and they tried to replace the harsh punishments with less severe punishments. So for all of this, you got 1 mark to explain how or what they started doing, and 1 mark, of course, for the first occupation of the English. Then the second British or English occupation, and here they brought a number of changes. And the changes, for example, the changes Afrikaans was replaced by English. They imported their own legal practitioners. They introduced the court hierarchy as we still know it today. They had a big influence on the civil and criminal procedure. Of course, also the merchants concluded contracts based on English law, so it had a direct impact on our mercantile law. So for all of these, you got half marks. And then, of course, around 1833, more importantly, started the Groot Trek, or the Big Trek. And what happened? Of course, the Boere tracked or moved inland, where they started 2 independent republics, the ZRR, as well as the Orange Free State. And what was important about this, and what did you get marks for? For saying or remembering that in these independent republics, in these Boer republics, they once again used the Roman Dutch law. But they also had a Supreme Court in the Transvaal and an independent judiciary in the Free State. And then, of course, in 1843, the British annexed Natal, and interesting enough, they continued with Roman Dutch law, but they also had a Supreme Court, which they established in Pietermaritzburg, and they could appeal to this Privy Court in London. So for all of this, you got 10 marks. All right. So let's go to our last question. Our last question, of course, dealing with Tapelo. He now has a dream of becoming an attorney. And I ask you to explain the admission requirements and then critically refer to the fit and proper test, specifically referring to the discretionary value judgment and the often political character of this test. So, many of you got so excited to start explaining the fit and proper test that you completely forgot to first explain the admission requirements. Now you will see in this question, as is the case in many of the other questions, there are more than 10 possible marks to get. So if some of you find that you get more marks, but that your mark is only out of 10, but you have like 13 or 12 ticks, don't get excited. You are very clever, but you can't get more than what the question counts. So you can't get 12 out of 10, in other words. Okay, so let's just quickly look again at the admission requirements. What are the admission requirements for an attorney? Well, we know that person needs to be older than 21, needs to be a South African resident, permanent resident or South African citizen, must have an LLB degree, must do the practical training or the articles, also must write the bar exam, and they must also apply to the High Court for admission. Then, of course, this person cannot be on the advocate's role, because remember, you can't be on both roles. And then, of course, this person needs to be fit and proper. And here, I did not give a mark for fit and proper because I already gave you the fit and proper requirement. But yeah, I wanted you, in terms of fit and proper, to discuss a number of things. Firstly, I wanted you to discuss what this fit and proper test means. And of course, this means, what is this test? This, of course, this test that is very short, lasts about 15 minutes, where this fit and proper test, where you are interviewed by senior counsel, and the senior counsel then tries and ascertain whether you have any previous convictions, criminal convictions, and whether you understand the profession's ethical rules and application thereof. And of course, this test doesn't last more than 15 minutes. And then this senior counsel will testify on the applicant's or on your behalf in court, and then the judge makes this discretionary judgment. Now, we have said in class 2 that this is a very subjective judgment. It's also at the beginning of the applicant's career, and perhaps this leaves some room for improvement, as it seems highly unlikely that you can already predict what kind of a lawyer this person is going to be. Then I wanted you to talk a little bit about the politics or the political nature of this test, and here you could refer to Gandhi and to the fact that females were not allowed or were not deemed to be fit and proper, as well as to some of the apartheid lawyers also not deemed fit and proper. And then, of course, you had to refer to the Prince case, the fact that he could not be fit and proper as he was at that point, a Rastafarian who smoked marijuana, and the court said he could not be deemed fit and proper because his behavior, his criminal behavior, could not be condoned. But now that the situation has changed, because it has been decriminalized or legalized, and private use of marijuana is now allowed.